So, hi everyone. We're going to continue with the classes of the Hindu law today. Okay. Under the sections of the Hindu law, we have understood about the conditions of a successful Hindu marriage and its provisions. Okay. So, when we're discussing about the conditions of a Hindu marriage, under this, we have discussed that there are certain conditions which need to be fulfilled for the validity of a Hindu marriage. Okay. So, you can ask me what are those conditions which need to be fulfilled for a valid Hindu marriage? So, the conditions we have understood and discussed. Those conditions are certainly like neither party has a spouse living at the time of the marriage. Like when the marriage is being done, getting done, then neither of the spouse, like either the husband or the wife, none of the spouse should be living at the time of the marriage. And the secondly, the condition we have discussed that at the time of the marriage, neither party is incapable of giving a valid consent to it in consequence of the unsoundness of the mind. That means when the marriage is getting done, both of the parties should have, when the marriage is getting done, both of the parties should have uh, like uh, should have at their soundness of the mind and should have capable to give the consent for the successful marriage. That means if I am a party to the marriage and you are a party to the marriage, and if we are getting married, that means we both must have the valid consent for the successful marriage. That means I should be happily marrying you, you should happily marry me. There should be the certain agreement, certain valid contractual decision between you and me that yes, we are getting married. And yes, this should be with the free consent. There should be no force, coercion, undue influence. The marriage should be done happily with the happy consent of both the parties, and that is the most important thing ever. Okay. So next thing, when at the time of the marriage, neither party is incapable of giving a valid consent to it in consequence of the unsoundness of the mind. When there is the unsoundness of the mind, that means any of the party is mentally unstable, any of the party is mentally mad, so we can consider that at this stage of the unsoundness of the mind, this is just unable, or the party, when the party is incapable to enter into the marriage or certain kind of the commitment, then it is the marriage is considered as a void marriage if the consent of the party has been taken when the party has the unsoundness of the mind. I am a mad person. I don't have the mental stability to decide what is right and what is wrong. I am mentally unstable, okay? And I don't have the mental stability to figure out what I am doing, what I should do, and what I should not do. So, if at that point of time I am entering into any specific kind of the contract with you, then that contract is considered as a void contract. We have discussed that in the Contract Act. In the same way, when I am having a unsoundness of the mind, I am mentally unstable, I am mad. At that point, if I am marrying a person without my consent, and even if it is with my consent, then that consent is not considered as a valid consent because that consent has been taken from me when I was not aware about the situation, when I was not myself knew that what I am doing and what I am not doing. I don't know what is the right thing or what is the wrong thing. I am just mentally unstable in nature. मेरा दिमागी हालत सही नहीं है. And in that condition, whatever kind of consent I am giving to you or to any person for a valid marriage, so can that marriage will be considered as a valid marriage? The answer is no. Unless and until both of the parties to the marriage is at a stable state of mind, both of the parties to the marriage has the mental sanity, mental soundness to enter into a valid marriage, then only the marriage is considered as a valid marriage, or else the marriage is considered as a void marriage in nature. Okay. So the next point, it is told that when the party is incapable of giving a valid consent, ये तो गया. The second point, though capable of giving a valid consent, has been suffering from mental disorder of such a kind and extent which to be unfit for a marriage and the procreation of the children. Obviously, the child production or getting a children is the ultimate goal of a marriage. We know, like in every marriage, after getting married, there is the next thing family expect from a couple, that to give the family a child. Okay. So basically it's a rule, like हम लोग हमेशा चाहते हैं कि हमारा जो फैमिली है वो आगे बढ़े. So if a person is incapable of taking care of the children or mentally unstable in nature, and the next most important is procreation of the children, that person is unfit to marry. That means the person is having certain kind of the mental disorder or certain kind of the issues upon which that person is incapable to produce a child or incapable for the procreation of his children. Yeah. When that particular person is incapable of for the procreation of a child, that means giving a child to the family, or the most importantly, that person is having at a mental state when he or she is unfit for the marriage, unfit to take care of his or her wife, his husband, his family. So when the person is mentally unfit for the marriage and procreation of the children, in that condition, those kind of marriage will be considered as a void marriage in nature. Okay. Then the most important and the next point we have studied, like it has been subject to the attacks of the insanity, recurrent attacks of the insanity. That means insanity means the mental disorder, that the person is always at a good mental state condition, but at certain point of time the person goes into a certain kind of mental state of insanity where he used to make harm to the people. So if there is any kind of situation associated over here, the person is suffering any kind of the mental insanity, in that condition, those kind of the marriage is considered as void in nature. The next point, the bridegroom has completed the age of 21 years and the bride at the age of 18 years at the time of the marriage. As we have already understood, the age of the majority for the male and female, that is 18 years of the old. And for the sake of the marriage, if we are talking about the marriage, for marriage, sorry for the interruption, guys. I have got a call. Okay. So, what I was telling, yeah, I was telling about the valid marriage itself. Okay. So, yeah. When we are talking about the conditions of the Hindu marriage, then under the what I was just telling you, when the person gets the attack of the insanity, that means the person is utmost time, the person is at having a very good mental condition, but for certain period of time, that person goes to a phase of the mental insanity or mental instability. Okay. So when the person goes to the subject of the recurrent attacks of the insanity, and if the person is having that mental imbalance or mental instability in nature, then that kind of marriage is considered as a void marriage if there is the absence of the consent of both the parties for that specific marriage. Okay, got it? Then when the bridegroom has completed the age of 21 years and the 18 years, as I have told you, for the valid Hindu marriage, the age of the male, that should be 21 years, and age of the female, that should be 18 years. Okay. So the age criteria between the male and female, that should be, for the female that should be 18 years, and for the male that should be 21 years of the age. The next point we have story, the parties are not within the degrees of the prohibited relationship unless the customs or usage governing each of them permits the marriage between the two. When there is the marriage between the two parties now, the two parties, they must not belong to any prohibited degree of relationship. So what do you understand by the prohibited degree of the relationship? Prohibited degree of the relationship means the parties should not consist from a particular category or particular degrees of the relationship. They should not be cousin of each other. They should not belong to same blood relations. The most important point is, if they are belonging to any kind of the specific blood relations, then those kind of the marriage between those parties is completely void in nature. For example, there is the, just go to the paternal side. You are getting your father's sister, their son, daughter. Like we in Hindi, we can just talk their mosi, papa ke behan, nana, nani. All these people we do have. Okay, so in these family blood relations, when there is a person is in according to the Hindu law or Hindu succession act or Hindu marriage act, those persons, for example, there is a boy who is my father's sister's son, मेरे पापा का बहन का बेटा है, वो मेरा क्या लगेगा, मेरा भाई लगेगा, right? So if I am marrying that person, so is it legally valid under the court of law? No, under the Hindu marriage, this is completely prohibited because this comes under the prohibited relation of the marriage. Got it? So the next point it says the parties are not within the degrees of the prohibited relationship unless the custom or usage governing each of them permits of marriage between the two. Until and unless the custom or the usage is permitting the marriage between the two parties, then the then except the custom boundaries, if there is any kind of marriage between the blood relations, between the relatives, between the sapinda relationships, that marriage is considered as void in nature. Clear? Got it? So the next point, if the parties are not sapindas of the each other, unless the custom or usage of governing each of them permits of a marriage between the two, unless until it is governed by the custom or it is permitted by the custom or the tradition, then if the parties are getting married between the sapinda relationship between each other, then the marriage is considered as a void marriage. And what is the sapinda relationship? That is specifically identifying any kind of specific blood relations between each other. And about that we will be studying at a later stage. I will make you understand in a detailed way what do we understand by a sapinda relationship. Okay, then yeah, one more thing we have discussed in the last class about the ceremonies of the Hindu marriage under the section 7 of the Hindu Marriage Act. Okay, so considering about the ceremonies of the Hindu marriage, we know that when we are talking about the Hindu marriage act ceremonies, there are certain rituals that need to be followed during the marriage agreement or during the time of the marriage. Okay, for example, there are the prathas of the Saptapadi, Pani Grahan, like there are a lot of things are there. For example, you know, when there is the marriage has been completed, the bride and the bride and groom, like they sit in front of the fire. There is that is the called the holy fire. There are the pandits who just utter the mantras. Okay, and like the both of the bride and groom, they take the sat feras. Okay, that is called the Saptapadi, 7 rounds that they are going to be the partners of the each other for the next 7 births. So all these traditions, the rituals need to be followed. Okay, there is the thing called sindoor, you know, we used to use, that is the like the pride of a married lady, the wearing of the sindoor, mangal sutra. All these things, that is the Hindu ritual, Hindu Sanskriti, like. So these things must need to be followed while we are considering a valid marriage. Okay. So the ceremonies of the Saptapadi, Panigrahan, and other rituals that need to be completed when there is the valid occurrence of a successful Hindu marriage. Got it? So the next point, we are talking about the registration of the Hindu marriage. So when we are talking about the registration of the Hindu marriage, it speaks that after the procedural completion of the Hindu marriage according to the proper rules and regulations, according to the proper social cultures and traditions, there must be the registration of the Hindu marriage for the purpose of facilitating the proof of the Hindu marriage. That means to make the marriage as proved, to make it proof that yes, the marriage has been successfully completed, the state government may make rules for providing that the parties to any marriage may have particulars relating to their marriage entered in such manner and subject to such conditions as prescribed in a Hindu register kept for this purpose. So, for the registration of the valid Hindu marriage, there must be the presence of the Hindu registrar. Yes. So, the registrar makes the marriage as to be registered. Like, the prathas, the paramparas, like the cultures, the tradition of the marriage that has been completed, right? After the completion of the marriage, ritually, there is the legal agreement, legal legal paper and legal pen and paper documentation of the marriage, which is considered as the registration of the Hindu marriage, which gives the legal documentation of the marriage and gives the valid proof of the marriage that yes, this marriage has been successfully completed, and from the day onwards these two people are going to be considered as the husband and wife of each other. Clear? Then the rules made under this section are laid before the state legislation. After they are made, the Hindu marriage register shall all reasonable time be open for inspection and shall be admissible as evidence of the statements therein contained and certified extracts therefrom shall in application be given the register and payment to him for the prescribed fee. Okay. So when there is the case in front of the registrar for the registration of a marriage, so what does the registrar does? The first step is the inspection, the investigation. Yes, in every case, whenever there is the any kind of the registration, that might be a legal registration, might be a marriage registration, might be a document registration, might be a case registration. The basic step before the registration is the proper investigation into the matter. The matter should be properly investigated before the registration of the document. That means before the registration of the marriage document or before declaring the person to persons as husband and wife, the registrar must do the basic inspection about the matter. Okay. And shall be admissible as the evidence of the statements contained and certified exact extracts of themselves and take the evidence of that. So what does the registrar do? For example, I am going with a person in front of the registrar and telling them that I need a marriage registration certificate. The registrar, before registering my marriage, will do the basic inspection that do I have the proper Aadhaar card? Do I have the proper PAN card? Am I a particular and valid Indian? Got it? After investigating into my proper background and my husband's background, the registrar will take certain proofs of the marriage, like the marriage documents, like the photos of the marriage, and the basic statements or evidences from the relatives, from me, from my husband. And after considering all the circumstances, when it is concluded by the registrar, yes, both the parties are actually husband and wife in nature, and they should be granted the marriage registration certificate, then the fee for the specific registration of the marriage is being taken, and the marriage is validly and authentically registered. Clear? Notwithstanding anything contained in this section, the validity of the Hindu marriage shall in no way be affected by the omission to make the entry. What does it speak? It speaks that notwithstanding anything contained in this section, validity of any Hindu marriage shall in no way be affected by the omission to make entry. That means the validity of the Hindu marriage is not going to be affected by the omission to make the entry. That means if there is the non-registration of the marriage, but there is a successful completion of the marriage. मान लीजिए the husband and the wife, they have officially married. Okay, there is the proof of the photocopies. There is the with the presence of the all the relatives, the family. The marriage has been done properly, but due to certain circumstances, the couple has not done any kind of the marriage registration. So the point arises, like if there is the omission of the marriage registration or the marriage entry, then is the marriage is void in nature? The answer is no. The registration of the marriage is not that much compulsory. If according to the proper rituals the marriage has been done, then the marriage is considered as a valid marriage. Obviously, there must be the presence of the family, presence of the relatives, there must be the photos of the marriage. So if all these things has been present from a marriage, then that marriage is considered as a valid marriage itself. And the validity of the Hindu marriage is not going to be affected if the marriage is just not registered or is non-registered, or if it is lacking of the legal compliance of the documentation of the registration. Okay, clear? Then we are coming to the point of the restitution of the conjugal rights. Restitution of the conjugal rights means the restitution means separation of one party from the society of the another party. That means एक छोटा सा एग्जाम्पल देती हूँ. आप और मैं, मान लीजिए हम दोनों पति पत्नी हैं, we are husband and wife. So in a certain circumstances, what is happening that after getting married to you, I have been dissatisfied with you, or certain kind of things that is going in my mind, and after which I don't agree to stay with you. So without giving you any proper reason, without giving you any proper explanation, I am getting away from you, or I am leaving your place, and I stopped staying with you, I'm not staying with you. So this kind of the condition is called as the separation. And when there is the separation without any specific reason, any of the spouse, any of the party can sue for the restitution of the conjugal rights against the another party or against the another spouse. Okay, so let's read it out for section 9 of the Hindu Marriage Act. When either of the husband or wife has, without any reasonable excuse, withdrawn from the society of the other, the aggrieved party may apply by petition to the district court for restitution of the conjugal rights, and the court, on being satisfied of the truth of the statements made in such petition, and that there is no legal ground why the application should not be granted, may decree restitution of the conjugal rights accordingly. Okay. So what does it speak? When either of the husband and the wife has, without reasonable excuse, withdrawn from the society of the other. That means when any of the parties, like either the husband or the wife is withdrawn from the society of the others. एक दूसरे को सोसाइटी से खुद को विड्रॉ कर लेती है, गेटिंग अवे फ्रॉम द सोसाइटी ऑफ द अदर विदाउट एनी प्रॉपर रीजनेबल एक्सक्यूज। मान लीजिए आई हैव बीन गॉट मैरिड फ्रॉम लास्ट 2 years, मैं 2 साल से शादी कर चुकी हूँ, मान लीजिए, ओके, दो आई एम नॉट मैरिड, आई एम जस्ट गिविंग एन एग्जांपल। मान लीजिए आई हैव बीन गॉट मैरिड फ्रॉम लास्ट 2 years, बट आफ्टर द 6 to 7 months ऑफ द मैरिज my husband started living separated from me, okay, and from the society of the other person it has been written. From society of the other person means I am having a family, I'm living with my sasural, unka saas ससुर, un my family, I'm living with them, okay, and suddenly my husband started living separately from me, and there is no proper reasonable excuse from his side that why that person is living separately from me. There is no reasonable excuse of that, okay. Even if I tried to ask him that why you are not living with me, what is the problem, the person is not agreed to tell me anything that why that person is staying away from me, or that person has got all the contact with me from last 1 year. So even though I am married to someone, I am living alone, and my husband left me without any specific explanation, without any specific reason, without any specific conclusion. I don't know what is the reason why that person is staying away from me from last 1 year. Got it? So in that case, I can file against my husband the restitution of conjugal rights. Conjugal right means the right to conjugate together. Conjugate means staying together. Obviously, if I am married to someone, I have all rights to stay with that person, stay with that family. Got it? That is the right of every married lady. So if my husband is staying away from me, so obviously this is my right to file for a restitution of the conjugal rights against my husband. That yes, my husband is staying away from me and I am unable to get all kind of benefits which I would have get if I would stay with my husband. Got it? So in this case, if the court feels good, if the court feels valid that yes, the point of that girl is totally fine, totally valid, the point whatever the girl is saying that the her husband has been left the woman from last 1 year and there is no valid reasonable explanation, the girl never knows where the husband is, what he is doing. So the here the court takes the case of the restitution of the conjugal right, and the court, this is the responsibility of the court to find out the husband and to give a notice to the husband to come back to the wife and stay with her. यहाँ पे कोर्ट का ड्यूटी क्या होता है? रेस्टिट्यूशन ऑफ द कंजुगल राइट फाइल करने के बाद कोर्ट का पहला ड्यूटी होता है टू फाइंड आउट द हस्बैंड, वेयर इज ही, वो कहाँ पर है, उसको निकालना, उसको ढूंढ के निकालना पहला रिस्पॉन्सिबिलिटी होता है कोर्ट का। दूसरा रिस्पॉन्सिबिलिटी होता है आफ्टर गेटिंग द एड्रेस ऑफ द हस्बैंड, दिस इज द रिस्पॉन्सिबिलिटी ऑफ द कोर्ट टू इन्फॉर्म द हस्बैंड टू कम बैक टू हिज वाइफ। आप अपने वाइफ के पास वापस जाओ, वो आपका इंतजार कर रही है। टू इन्फॉर्म दिस टू द हस्बैंड, दिस इज द बेसिक ड्यूटी ऑफ द कोर्ट। यस, द सेकेंड थिंग, the statements made in such petition and there is no legal ground why the application should not be granted, okay, the decree of the restitution conjugal right can be issued. But if there is sufficient ground for the leaving of the husband, for example, husband has been and given me the sufficient reasons, like I don't want to stay with you because you are having the extramarital affairs, or you are a Muslim, or certain kind of things, like I am having any kind of the problem which is bothering him. So if the husband is clarifying the specific reason, then the restitution of the conjugal rights is not valid in nature. The decree of the restitution of the conjugal rights against any of the spouse, it might be the husband or it might be the wife, it can be issued at a point of time when the both of the parties are living separately at that point of time, and there is no specific explanation near the another spouse from the another spouse. For example, if I am a wife, if my husband has left me, or if I am a husband and my wife has left me from last 1 year or last 6 months, 7 months, 8 months, and I don't know the specific reasons of his or her departure, आई डोंट नो उसको क्या हुआ, उसने क्यों मेरे को छोड़ के चली गई, देन इन दैट केस आई कैन फाइल a suit for the restitution of the conjugal right, and this is the duty of the court to take up the matter and order the another spouse, that might be the wife or might be the husband, to come back to the family, to stay with the family, to stay with the wife or to stay with the husband. Got it? This is called the restitution of the conjugal right. Restitution means the recover. रिस्टोर का मतलब क्या होता है? फॉर एग्जाम्पल आपका फोन पे जब फॉर्मेट होता है आपका क्या होता है? रिस्टोर होता है. आपका कोई भी फाइल होता है, अगर वो फाइल लॉस हो जाता है तो आप उसी को रिस्टोर करवाते हो, उसी को फिर से फोन में डाटा स्टोरेज में उसी को वापस लाते हो, तो उसी को बोलते हैं रिस्टोर करना. दैट मीन्स हियर द conjugal right need to be restored when there is the conjugal right between whom the husband and wife is getting hampered. If I am a wife or I am a husband, I have the all the rights. मेरा पूरा हक है अपने पार्टनर के साथ रहने का. अगर वो राइट मेरा वायोलेट हो रहा है, देन उस राइट को रिस्टोर करना, रेस्टिट्यूट करना किसका रिस्पॉन्सिबिलिटी है? दिस इज द रिस्पॉन्सिबिलिटी ऑफ द कोर्ट ओनली. गॉट इट? So this is about the restitution of the conjugal right under section 9 of the Hindu Marriage Act. And from section 10 of the Hindu Marriage Act, we are going to study about the judicial separation, that we are going to continue from the next class itself. This is all for today. Thank you.